Welcome to class 2. Today we're going to be talking about the difference between marijuana and hemp. Now, this is very important you understand this not only from a legal perspective, but also from an operational perspective. What's going to happen is clients are going to call you, and they may think that they want to get into the hemp industry, but after you ask them some questions, they're going to realize really they want to get into the marijuana industry, and vice versa. Clients may call you thinking they want to get into the marijuana industry, but really what they need to get into is the hemp industry. And so it's very important you understand the distinction legally and operationally. So what we're doing here is we have a little diagram similar to what we looked at in course 1, but it's important we continuously go over this. So you have cannabis, right? The cannabis is the overall plant. It's broken down into hemp and marijuana. Hemp is defined as having 0.3% or less THC. Marijuana is defined as having more than 0.3% delta 9 THC. So what we're going to do is we see that hemp can be broken into flower, stalk, seed. Marijuana, we're really just talking about flower mainly. And the main uses are medical, recreational, and then spiritual and sacramental. So we went over a lot of that in the previous class. We're going to be digging even deeper in this class. Now, what we have from a legal perspective, like the legal framework you got to worry about on the hemp side is this right here. You have the 2018 Farm Bill. That was an act of Congress. And what that did is it really made this distinction so that hemp is now federally legal. Marijuana, still federally illegal. Now, what you have from the 2018 Farm Bill is it said as long as something is called hemp, the DEA no longer has authority over it. It's no longer a Schedule I substance on the CSA. So DEA should no longer have authority over hemp. But what it did is it said the USDA is going to come out with rules, and each state is going to come out with their own program that needs to be submitted to the USDA for approval. So you have the USDA and the states that are really making out what the hemp production program is going to look like. Now, what you also have is the 2018 Farm Bill explicitly preserved authority for the FDA to basically regulate food, dietary supplements, cosmetics, and drugs. Now, that's in the FDA's authority no matter what. So the 2018 Farm Bill really just clarified that it's not changing anything with respect to the FDA. So we're going to go through the legal and operational considerations. We're going to talk about how hemp products need to have packaging and labeling that's compliant with state law, but also federal law. So you have the state and the federal when we're talking about packaging. When we're talking about packaging for marijuana, we're really only dealing with state law because marijuana, once again, is federally illegal. Now, we're also going to go into basically that the FDA makes CBD illegal to be used as a food or marketed as a dietary supplement. You also can't make any health claims with respect to CBD or really any of these cannabinoids. And we're going to dig into even the minor cannabinoids. And then we're also going to talk about the contracts and the business relationships you see throughout the entire supply chain for both hemp and marijuana. So on this next slide, we're going to go over the main differences between hemp and marijuana. So number one, like we said, hemp is federally legal pursuant to the 2018 Farm Bill. Marijuana is federally illegal. It's on the CSA as a Schedule I controlled substance. Now, what Schedule I means is that it has no medical value and has a high likelihood for abuse. So that's why the medical marijuana community is so upset about this, because they think those two elements just don't exist here, and therefore marijuana should be rescheduled. But currently, marijuana is Schedule I. Now, the next difference between the two that we have on this slide is that hemp operators are actually able to sell their products across state lines. In fact, the 2018 Farm Bill explicitly says states cannot prevent hemp operators from selling these products across state lines. In contrast, marijuana companies can only sell their products within a particular state, so intrastate. So in the marijuana industry, very, very important. You could only really do business within your state. In the hemp industry, you could do business much more broadly and even import-export into other countries. In the hemp industry, anybody over 18 can purchase hemp products unless the state explicitly says otherwise. In the marijuana industry, either what you have is you have a medical framework where you're going to have to be over 21, you're going to have qualifying conditions. Now, in the medical framework, there are some exceptions for children that also have these qualifying conditions, but it really depends which state you're in. On the recreational side, it's generally 21 or over, very, very similar to what you see in the alcohol industry. So the goal, if you're a hemp operator, is to keep your product underneath 0.3% Delta-9 THC. It is a huge focus. If you are a cultivator and you are cultivating marijuana, or if you're a processor and you're processing marijuana versus hemp, the goals that you have are very different. For marijuana, you're trying to get high THC. You're trying to have high THC concentration. You have different goals, and that's going to really control your operations. On the hemp side, because you want to keep the THC levels low, you're going to cultivate in a totally different way so that you can properly control those levels. On this next slide, we're going to talk about the legal and operational considerations for marijuana versus hemp. Now, hemp, like we talked about, is federally legal pursuant to the 2018 Farm Bill. Marijuana is currently federally illegal pursuant to the CSA. The Controlled Substance Act has it as a Schedule I substance, which means that it has no medicinal value and a high likelihood for abuse. Also, hemp, on the one hand, can be transported interstate. In fact, the 2018 Farm Bill explicitly prohibits states from stopping companies from transporting interstate. Now, on the marijuana side, you can only do business within your state. So it's all intrastate for marijuana. Now, in the hemp world, really you just need to be 18 or older, and this is really mainly controlled by the states, whereas in the marijuana world, it really depends if you're in a medical or recreational state. For medical, they're generally going to require that you're over 21. But there are some exceptions for children that have qualifying conditions, right? So in the medical framework, you need to have a qualifying condition. If you're over 21 with a qualifying condition, that's fine. If you're under 21, some states have certain exceptions and additional hurdles you have to meet in order to get a medical marijuana card as a minor. Now, what you also have is that from an operational perspective, the focus on hemp producers, whether they're cultivators or their processors, is really on just keeping the product from going hot. What does hot mean? It means going over 0.3%. So if you're a hemp cultivator, that is your main focus. When you're talking about your harvest or what varieties you're planting, you're going to be focusing on what varieties and what process I could implement and how do I sample this so that I could keep my product underneath that 0.3% Delta-9 THC level. Whereas in the marijuana world, you're focused on varieties oftentimes that are high THC and have high THC content. So really it's a very, very different focus from both a legal perspective, but also an operational perspective. So moving into this next slide, what we're going to be discussing is the hemp legal framework. And I have it right here. This is really, in essence, what you need to understand if you're working in the hemp industry. So the 2018 Farm Bill, before that, there was the 2014 Farm Bill. What the 2014 Farm Bill did is it created a pilot program for people to do some research. It still was an illegal substance and was still classified with cannabis. But what the 2018 Farm Bill did, it came in and took it out of just research, and it now allows us to commercialize hemp. As long as the cannabis is 0.3% or less Delta-9 THC, we can then commercialize the hemp. So what it did is it said, DEA, you're done. If it's considered hemp, the DEA no longer has authority over it because it's no longer on the CSA. But what it specifically also did is it preserved authority for the FDA. So as long as you're using hemp as a food, dietary supplement, cosmetic, or a drug, what they've done is they said the FDA still has authority over that. And that's no surprise. The 2018 Farm Bill probably didn't even need to mention that because that is within the FDA's authority. That's what the FDA is set up to do is they're set up to handle food, drug, dietary supplements, and cosmetics. So any one of those products is going to be regulated by the FDA. So it's very, very important that you understand FDA regulatory law. I am not an FDA attorney, so what I did a couple years ago is I actually brought on board an FDA regulatory attorney. Edgar Aspie, he's of counsel with our firm. He's an incredible FDA regulatory attorney. He's been working for decades. So this is very important for you to understand. If you're practicing cannabis law, I would highly recommend at least having a resource of someone who's very, very familiar with FDA regulatory law. That is an extremely important point. And by the way, even on the marijuana side, right now, because it's federally legal, we're mainly dealing with the states. But my prediction is as the federal government opens this up and makes it legal, which may be down the road, what we're going to see is we're going to see the FDA taking authority over marijuana as well. So very, very important that you really understand FDA regulatory law. And if you're not an FDA attorney, you should really partner up with somebody that understands FDA regulatory law. Now, we talked about the 2018 Farm Bill preserving authority for the FDA, but what it also did is it basically said the USDA is going to oversee this program, and what's going to happen is the USDA is going to come out with rules, and those states are going to come up with their own programs. Now, the state programs can be more strict than the USDA rules. They cannot be less strict than the USDA rules. So what happened is the USDA came out with interim rules. The states then passed their own program that then needed to be submitted to the USDA and were approved by the USDA. And then subsequent to that interim rule, the USDA came up with a final rule. And so now the states need to go back and they need to revise their programs to be consistent with that USDA final rule and then resubmit to the USDA for approval. I know that's very complicated. Essentially, the main thing to understand is that states need to have their program approved by the USDA, and the state's program can be more strict, but not less strict than the USDA program. So what did the USDA final rule have in it? It had a few very, very important points. Now, one of the things it did is that the interim rule gave a 15-day window to do testing. The final interim rule changed that and made it a 30-day window. Why is this important? Because I talked about in the hemp world, all we're focused on, the main focus is going to be that 0.3% Delta-9 THC. So the earlier we could test that product in the harvest time, the earlier before the harvest, the more likely you're going to have 0.3% lower readings. You're going to have a lower Delta-9 reading. So what happened was the final interim rules allowed you to basically take a sample within a 30-day window. That means you're sending a sample to the lab in a 30-day window, and meanwhile the product still might be getting more and more THC content. So at the time of harvest, it's possible that you're actually above the 0.3% Delta-9 THC. However, the lab might give you a certificate of analysis that says you're below the 0.3% Delta-9 THC. So this change was very important, that 30-day window. Now, what they've also done is they've relaxed the requirements on sampling, which has been very important and also helps with the 0.3% Delta-9 THC reading. What they've done as well is the testing is done on total THC. Now, this has been the rule in the 2018 Farm Bill. It talks about 0.3% Delta-9 THC. What they've done is they've clarified is that this is a total THC test. So not only are you testing THC Delta-9, you're also testing THCA, which is very, very important. It makes it a little bit harder to meet this 0.3% requirement. They've also relaxed the disposal requirements for hot hemp. So if you test hot, if you test above the 0.3%, before they had all these different hurdles and requirements you had to go through to destroy your crop, the 2018 or the USDA final rule basically relaxed that and made the destruction a lot easier. And then finally, one of the other big things that they did is that originally in the 2018 Farm Bill, there was a requirement for the labs to have a DEA registration. Now, this this is a long process. Number one, the labs need to change their operations so that they can invite the DEA in and actually be registered. And what happened is that there's very, very few DEA registered labs. So this would have created an enormous bottleneck in the industry. So what the USDA final rule does is it actually pushes that requirement to be DEA registered. It pushes that to the beginning of 2022. So January 1st, 2022 is when these labs will need to be DEA registered. So hopefully by then we'll have a lot of labs DEA registered, so we won't have any sort of bottleneck when it comes to testing. Now, I mentioned that the DEA shouldn't really be involved in hemp, right? The 2018 Farm Bill said as long as it's considered hemp, the DEA shouldn't be involved. However, the DEA came out with an IFR, an interim final rule. And in that interim final rule, they agreed, we have no authority over hemp and we're just putting this out to make clarification. However, they clarified two items that have been very, very hot topics. Number one, so even if the product goes above 0.3% just temporarily, it's still considered hot and therefore is within the DEA's authority, say it's illegal. Now, the reason this is an issue is because when you're processing hemp, it will inevitably, when you're extracting the hemp, it will inevitably go above 0.3% for a temporary period of time, and then it's brought below 0.3%. So when this came out, when the DEA IFR came out, the entire hemp processing community was up in arms. Essentially, it would have shut down the entire hemp industry. But what happened was, from a practical perspective, the DEA isn't really enforcing this right now. We don't know what the DEA will do in the future, but realistically, it's nearly impossible to extract hemp and go through that process without it temporarily spiking above the 0.3%. So that DEA IFR really clarified, hey, even if it's temporarily hot, it's still hot and the DEA has authority. Now, the second controversial thing that was in that IFR is that the DEA basically said that synthetic THCs are still illegal. So synthetic THCs is not really defined. So we don't necessarily know what they meant about the synthetic THCs, but this is very, very, very important when it comes to the minor cannabinoids. And we're going to talk about this in future slides. But pay attention. What you're going to see is that a lot of these companies are moving away from just doing CBD, which grows in high concentrations, and instead are starting to convert the CBD using a synthetic process into other cannabinoids. So whether or not that is an illegal process is still within a gray area. So on the next slide, what we're going to do is we're going to be talking about the packaging and labeling requirements, right? So the FDA requires that the operators disclose certain information. So if you're dealing with hemp labels, you're going to not only have to deal with your state's hemp laws, you're also going to have to deal with the FDA's labeling laws. And it's very, very important you're familiar with both. And so what's really complicated, I mentioned that hemp companies can ship interstate, but the challenge is that each state has their own labeling and packaging laws. So if you're a hemp company and you sell into all of the states, it is nearly impossible to remain compliant from a labeling and packaging perspective with all the different states. So we have some different strategies, and in the textbook we go through, essentially we provide a chart that goes through all the different labeling requirements, and as long as you go through that chart and you check off each of those requirements, you should be about 98% compliant with every single state's laws. So essentially, stick to that chart, reference that chart, and make sure you understand that chart. The main things that they're going to require on there is that you need to say the manufacturer's name. You need to have a certificate of analysis, which shows that it's below the 0.3% Delta 9 THC. You may need to have warning claims on there. You're going to have contact information. There's a whole list of items. Like I said, make sure you reference the textbook, because the textbook really has a long explanation of all the different stuff that is required. So one of the other things that's important is that if you're selling hemp as a food, you should have a nutritional panel, right? You need to have certain requirements that are on that nutritional panel. If you're selling the hemp product as a dietary supplement, you're going to have a supplement panel, and there's certain requirements in a supplement panel. Once again, all that information is in a lot of detail in the textbook, so make sure you read the textbook. So moving on to the next slide, what we're going to talk about is the FDA's oversight. So really, the main thing to understand is right here. For the FDA, there's something called the drug exclusion rule. There's also a requirement for pre-market approval for dietary supplements. There's GRAS, which is generally recognized as safe. And then there's health claims. So we're going to go through each of these. But what you need to understand with that, what the drug exclusion rule says is that if there is a particular ingredient that is in a drug that has already been approved by the FDA, or that is a part of investigational drug development, you cannot market that product as a dietary supplement, and you cannot use it in a food. So what happened was there was Epidiolex. Epidiolex is a very highly concentrated version of CBD. Now, CBD is an ingredient in Epidiolex. So pursuant to this drug exclusion rule, basically CBD cannot be sold as a food or as a dietary supplement. Now, there's an exception to that drug exclusion rule if the product has been marketed prior to that investigational drug going through its investigation and being approved. Now, that's debatable whether it was, but essentially the FDA's position is that there's no evidence that CBD was marketed prior to this investigational new drug. So essentially what that means is that if you're using CBD in a food or dietary supplement, basically pursuant to the drug exclusion rule, it's not allowed. So very, very important. You're very familiar with the drug exclusion rule. So what a lot of clients are looking to do is they're trying to say, we're not using the ingredient of CBD. Instead, what they're doing is they're trying to have natural hemp extract, right? We know that this plant basically produces an extract when you extract it that has a lot of cannabinoids, CBD, CBN, CBG, delta-9 THC, delta-8 THC, all these different cannabinoids. So what these companies are doing is they're arguing that this hemp extract is a different ingredient than the highly concentrated version of CBD that is in Epidiolex. The FDA has not taken a position whether that will actually hold up against them, but that is one of the strategies that some companies are using, and we discussed that in a lot of detail in the textbook. So it's important that you're very familiar with that. So the other thing, pre-market approval. So if you're selling something as a dietary supplement, it needs to have pre-market approval, or it needs to be GRAS, generally recognized as safe. Now, the seeds of hemp are generally recognized as safe. If you want to use the seeds in hemp in a food or as a dietary supplement, you're good to use them. The seed oil is what we're really referring to. The seed oil is what is GRAS. The flower, the extract that comes from the flower, the CBD, the CBN, the CBG, there's no GRAS recognition. So in other words, if you're selling a CBN, a CBG, a CBD product, you would need to go through this pre-market approval, and currently none of the companies are really going through that pre-market approval. So those products, even the non-CBD products, which we're going to get into more detail in a bit, are also potentially illegal. Lastly, and probably most importantly, if you're a hemp company, when you're making a health claim, you're essentially now putting your product in the drug category. So the FDA classifies products based on their intended use. So it's either a food, a dietary supplement, a cosmetic, or a drug. And as soon as you make a health claim, like for example saying this is going to help with cancer, this is going to cure arthritis, those are health claims. And now you're in the drug world. And if you're marketing it as a drug, you need to go through a very lengthy and expensive process of getting it approved as a drug. So a lot of these hemp companies are making health claims, and that is when you get the FDA's attention. This, the drug exclusion rule, just selling it as a food and dietary supplement, doesn't really get the FDA's attention. Still not allowed, doesn't really get their attention. Even not qualifying for these doesn't really get the FDA's attention. But as soon as you make any health claims the DEA is going to be, or the FDA is going to be all over you, and they're then going to come after you for this, this, and this. So you want to make sure you make no health claims. Now, there's a difference between a health claim and a structure function claim. I'm not going to get into that in detail now, but in the textbook, there's a lot of detail and examples for what's considered a health claim versus what's considered a structure function claim. And if you're in the marketing department of your particular company, if you're an attorney that's advising this company or the marketing department, you need to be very, very familiar with the distinction between health claims and structure function claims. So the next slide, what we're going to do is we're going to go over how they're handling other cannabinoids. So we kind of just discussed that CBD can't be used as a food or dietary supplement or marketed as a dietary supplement because of Epidiolex, because of this drug exclusion rule. So the big question then is, what about all these other cannabinoids? So first, what I want to do is deal with delta-8 THC because it's kind of in its own world. So delta-8 THC, it's a double bond isomer of delta-9 THC, and it's generally found at very low concentrations in cannabis. So delta-8 comes from hemp, but it grows in very, very low concentration. So you would need to grow hundreds of thousands of acres to get a lot of delta-8, but a lot of people want delta-8. The consumers want delta-8. So rather than growing hemp naturally and growing hundreds of thousands of acres just to extract a very little amount of delta-8, what they're doing is they're taking CBD isolate and they are converting it to delta-8 THC. So it goes through this isomerization process and it creates delta-8 THC. So what the big question is, I referenced before that the DEA came out with an IFR, an interim final rule, that says synthetic THCs are illegal. They didn't specify that they were referring to delta-8 THC, but they said synthetic THCs are illegal. Now, on the other hand, the 2018 Farm Bill explicitly says that hemp, all of its cannabinoids, all its isomers, and all of its derivatives are legal. So the question is whether delta-8 that is created through the process of converting CBD into delta-8, whether that is synthetic or whether it is a derivative and legal. If it's a synthetic THC, then the DEA says it's federally illegal. If it's actually just a derivative of hemp, the 2018 Farm Bill says it's legal. So that is really the crux of what we're dealing with when we're talking about delta-8. Now, I could talk for hours about delta-8, but it's very, very important that you understand the main crux of the argument is this synthetic versus derivative. Now, what's interesting is all we've talked about thus far is the federal government's position, but states are allowed to be more restrictive than the federal government. So if the state wants to have their legislator pass a law that basically says that delta-8 is illegal, even if it's derived from hemp, a state could do that. They could be more restrictive. Or what we're really seeing is we're seeing departments of agriculture or departments of health or departments of consumer services within these states come out with policy statements or pass rules making delta-8 illegal. Now, that has its own challenges. I think that there's going to be administrative challenges against these Department of Agriculture for making some of these claims. For example, what we're seeing in Kentucky is Kentucky totally missed the ball. So Kentucky didn't pass any law, but instead the general counsel for their Department of Agriculture, for the Kentucky Department of Agriculture, takes the position in a policy statement. So they don't pass a law, they don't pass a rule, but the general counsel comes out with this opinion that essentially says that delta-8 THC is illegal. Whether it's synthetic or natural, he makes no distinction, and it is a vast misunderstanding of the 2018 Farm Bill and the DEA IFR. In my opinion, the general counsel got it totally wrong, and in addition, the general counsel really doesn't have the authority to just change law through an opinion statement. But anyways, many states, at this point I think we have at least 12 states that in some form have either banned through law or through a policy statement have banned Delta 8 THC. Here in Florida, there's no ban on Delta 8 THC. So we still aren't sure from a federal perspective what the DEA's position is, specifically with Delta 8 synthetically derived. But here in Florida, they're really not doing anything at a state level if you're producing and selling Delta 8 THC. In fact, I've invited Florida Department of Agriculture and Consumer Services into some of the facilities for some of my clients so that they could see the Delta 8 production and the products that they're selling in Delta 8. And Florida Department of Agriculture and Consumer Services is perfectly fine with it. Essentially, they're waiting to see what the DEA does. As long as the DEA sits back, they're going to sit back. Now, you also, one other thing I just want to point out, despite my understanding of synthetic, the federal government has historically, the DEA has historically considered something synthetic that is really totally created in a lab. So some examples of that are like K2 and spice. Those are synthetic THCs that are totally created in the lab. In contrast, the Delta 8 is actually derived from hemp, a natural product. So I think what we have with Delta 8 is much different than what the DEA has historically considered as synthetic THC. However, certain states, such as Colorado, have come out and said specifically that the process in which Delta 8 is created is considered synthetic and therefore it is illegal. And even going further, some states haven't even talked about specifically the Delta 8 THC. They basically just say any synthetic process is illegal. Any synthetic cannabinoid is illegal, which would actually mean that CBG and CBN within those states that's synthetically derived is also illegal. And similar to Delta 8 THC, CBN and CBG are at very, very low quantities within the plant. So CBN and CBG are also created through a synthetic process. So at the DEA's level, they've specified synthetic THCs, but at some of the state levels, they're saying synthetic cannabinoids, which could potentially impact the CBN and the CBG. So we kind of just talked about the minor cannabinoids and the challenges with the DEA, but really quickly, I want to kind of transition back to the FDA, because there's a lot of misconceptions that CBG and CBN, because they fall outside of the drug exclusion rule, right? There's no current FDA approved drug at an FDA level that has been approved using the ingredient of CBN or CBG. So it falls outside the drug exclusion rule. So people say, great, we don't have the same issues as CBD. But what they neglect to take into account, that CBG and CBN are not grass. They're not generally recognized as safe, and therefore they need pre-market approval from the FDA. And currently the companies selling these products are not getting pre-market approval. So most of the CBN and the CBG products that are currently being sold are actually also being sold illegally from an FDA perspective. So it's very important that you not only focus on your state's laws, you need to understand the DEA's position, and then you also need to understand the FDA's position. So going to the next slide, what we're going to be talking about is the contracts throughout the supply chain. And I will tell you, one of the biggest things I have to keep repeating to attorneys is do not use standard form contracts in the cannabis industry. You just can't. There's too many distinctions in laws. You need to know the laws, but you also need to understand the operations of your client in order to properly draft a contract. So what I did in the textbook is I went through each of these contracts in great detail, but I'm going to just hit on them really quickly, each of these, and kind of point out the main issues you need to watch. But the big issue in a lot of these, if you're dealing on the hemp side, is you're going to need to have some provision in there that basically accounts for that 0.3% total THC. So if you're doing a lease agreement, you're the landlord, and you're representing a landlord, and the tenant is going to be leasing the property to grow hemp, you want to make sure that there's an allocation of risk of if that product goes above 0.3% THC. If you're doing a purchasing contract and you're a processor and you're buying from a cultivator, you're going to want a provision in there that accounts for that 0.3% delta 9 THC. So there's certain aspects in the hemp industry that should really be accounted for in every single contract. So let's just go through some of the contracts we have on this slide. So we have real property contracts. So a lease agreement. I'll give the example of a marijuana lease, right? So the challenge with marijuana, federally illegal. So when you enter into a lease, most leases are going to have language in there that explicitly says that illegal activities are a breach of the contract. You need to remove that, or at least create an exception that explicitly says marijuana is allowed to be grown or processed or sold at that particular property. So in the lease agreements, you need to account for the fact that this is federally illegal activity, right? Number two, a lot of these states have certain restrictions on who could have access to these facilities. So you're going to see in a lot of lease agreements, landlord-tenant lease agreements, where the landlord wants to have access to come in if he has, gives 24-hour notice, or sometimes there's just no notice required. But if the marijuana law for that particular state limits access to certain individuals, you need to account for that in the lease agreement. Number three, one of the other big challenges in the marijuana world for any real estate contract is that since it's federally illegal, the landlord is likely going to have a mortgage on that property. All mortgages, or most mortgages from any institutional banks, are going to say that no illegal activities can be conducted on this property. So therefore, if you're a landlord and you're planning to lease to a marijuana company, you could potentially be in breach of your mortgage, which means they would be able to foreclose on you. So those are some of the issues with some of the lease agreements. You also have crop sharing agreements. These are very popular in the hemp industry. So I get calls all the time for people that own land in North Florida, and what they'll say is, I don't know anything about hemp, but I want to make money off of it, right? Could you introduce me to someone that knows how to grow hemp? So I'll introduce someone who knows how to grow hemp. I'll introduce them to a landlord, someone who owns property. And what they'll say is that I don't need any lease. You don't need to pay me a lease, but I want to share in the profits of selling this crop. So in crop sharing agreements, it's very, very important you allocate responsibilities. You say who's responsible for what expenses, and then have a very clear delineation on how those profits are to be distributed. Next thing I have on here is a sale-leaseback agreement. These are very popular in the marijuana industry. Early in the marijuana industry, it was all about acquiring assets. People wanted to own their land. They wanted to own licenses in all these different states. And then the stock prices just plummeted. So these companies had trouble raising capital to become operational. So what the sale-leaseback does is it allows these marijuana companies that own land, it allows them to sell that property to someone, get the cash, right? Sell the property for $1 million, get $1 million of cash, and then enter into a lease agreement where they're paying 50 grand per month. So from a cash flow perspective, sale leasebacks are extremely important in the marijuana industry. Next category we have is intangible and personal property contracts. The main contract in this category is licensing agreements. That has become extremely popular for marijuana companies. The reason is just like I explained before, marijuana companies cannot transport interstate. You can't transport between each of the states. So if you're a California company that has a unique process or a unique brand or some other IP, you cannot ship your product into Florida. So how do you expand into Florida? What you do is you do a licensing agreement with a company that has a Florida marijuana license. So in that licensing agreement, what you're going to be doing is you're going to be licensing out that technology or that brand or that IP to that company so that you can now expand your product into Florida. So let's assume you're a California company and you have a product that is specific for dosing marijuana, and there's a certain way that you create this product, and that's IP, and that's a secret to you guys, and there's a certain brand name attached to that product, right? So you have some IP around this. Now, if you're that company that owns that IP, you're going to want to make sure that the quality of the product is good. You're going to want to make sure the process is done correctly, and you're going to want to keep that process a secret. So in normal industries, you may say, we're going to bring our own employees in They will produce the product to make sure that it's has quality and it's within Florida and that it could be sold and the packaging and the labeling is done, and we'll just take a royalty for it. But in Florida, Florida Statute 381.986 explicitly says that you cannot contract out for another company to do any part of the supply chain. So in other words, if you have a Florida marijuana license, your employees need to be the ones who are handling the marijuana throughout the entire supply chain. You cannot contract out. So now the company owning the IP is in a situation where they need to figure out how to structure this contract so that the people that are actually creating the product and that are privy to the intellectual property, they have to be employees of the medical marijuana licensee, but at the same time, the contract needs to be drafted in such a way as to create kind of a Chinese wall so that they will not be disclosing to other employees that process. So essentially, you got to be creative in this contract because of Florida Statute 381.986. And there's a bunch of different statute provisions in other states that you really need to be aware of if you're ever doing a licensing agreement. Even from a marketing perspective, Florida has certain laws on how you're able to market your product. So if you're a brand doing a licensing agreement down here, you need to be very familiar with those marketing laws. So next stuff we have on here is purchase and supply agreements. Once again, you're going to need to make sure that you are very specific on certain provisions. If you're a processor and you're acquiring hemp from a cultivator, where does the risk lie when if it tests above 0.3%? Who's responsible for the packaging? Who's responsible for the labeling? Who's responsible for the delivery? Those are all very key points. And once again, in the textbook, I get into each of these in great detail. Then you have business relationship contracts. For example, a consulting agreement. Let's say you're a farmer and you want to bring in someone who's an expert in growing hemp, and you enter into a consulting agreement. In that consulting agreement, you want to make sure you don't give that consultant so much managerial authority such that they control the activities, because if you do, now they're required to get a background check. Florida statute requires that if you're a hemp cultivator, anyone who has that managerial authority that can control the operations needs to have a background check. So you have a choice when you're drafting this consulting agreement. Either you need to make sure the way it's drafted doesn't give them that kind of control, or if it does give them that kind of control, you need to require them to get a background check, and you're going to need to submit that to Florida Department of Agriculture. So very important, once again, in that consulting agreement, that you understand the laws of the state you're operating in. Similarly, partnership agreements. So if you're an LLC and you're creating an operating agreement, there's certain laws that they have in marijuana states that really control the management and the ownership. So for example, to own a marijuana license, you really can't have a felony. So let's say you have two partners, right? They enter into a partnership agreement, and one of them, and they each put up tens of millions of dollars, right? And they're operating this company. It's worth $100 million. One of them gets arrested for a felony. What happens? The state is going to take away your license if that guy stays a partner. So that person needs to not be a partner. Does he just completely forfeit his interest? Is the other partner required to buy him out? How do they establish valuation? All of those considerations should be in your partnership agreement or your operating agreement. So it outlines what would happen, what the buyout would be if a partner ends up getting arrested for a felony. Similarly, a lot of these states require social equity applicants to own and control the license. So within that partnership agreement, if you're applying as a social equity applicant, you need to make sure that not only the ownership shows that it's above 51%, but you need to make sure that the way you're setting up the structure of management also gives that social equity applicant enough control. And we get into this in later chapters in even more detail, but very, very important that when you draft these operating agreements, you're not just using a standard form from another industry. Service contracts, you have seed transfer agreements. So for example, in Florida, you're required to use certified seed. That means that it's either certified by ayahuasca or it's coming from a pilot program. So if you're entering into a seed transfer agreement, you better be accounting for the fact that it needs to be certified seed. You have farmer servicing agreement. We kind of talked about that when I talked about the consulting agreement. Then we have processor servicing agreement and processor tolling agreements. These are very important to understand the difference between this. So let's say you're a farmer and you just want to sell your crop to a processor for extraction. You just enter into a purchase agreement. That's easy. But let's say you're a farmer and you actually want to build a brand, right? But you're not an extractor. You can't process your hemp into, let's say, CBD. So you're going to contract with a processor in either one of two ways. Either you're going to say to that processor, I just want to pay you a servicing fee. So I'm going to send you my hemp. You're going to service it. You're going to turn it into oil or a tincture or whatever you turn it into. And I'm just going to pay you a fee for that, right? That would be a processor servicing agreement. But let's say you're a hemp brand further down the supply chain and you've built out this brand and you actually have created your own formulas for CBD tincture or a gummy or whatever it might be. And you have a very specific way you want it done with certain specifications. You may say to a processor, hey, we want you to process our product, but it needs to meet these specifications. What that is that's a tolling agreement. That is you basically giving the specifications to the processor and saying, we want it done to these particular specifications, as opposed to just saying to them, hey, slap our label on it and we'll just call it a white label agreement product. So there's different types of arrangements all the way throughout the supply chain. You have distribution agreements, delivery agreements, drying service agreements. These are all different service contracts that really you need to be very, very familiar with the laws within the state and not rely on just some template from another industry. You also have financial contracts, whether it's rev sharing or profit sharing. Once again, do not rely on templates from other industries. You really need to have very specific provisions. Now, all of these contracts, basically what they are is they will require, if you're an attorney, to understand not only the legal aspects, but also the operational aspects of operating these companies. And really, if you want to understand that, go through the textbook. There's tons of really good information, and that's really where your focus should be, is really understanding not only the legal, but also those operational aspects. So on the next slides, what we're going to do is we're going to go through the do's and the don'ts. So do remember that labels and packages of hemp products are subject to both federal and state regulations, right? So when you're dealing with hemp, you want to make sure you're dealing with both the state regulations and the FDA federal packaging regulations. Don't forget that operating in the cannabis industry always requires operating in the gray area between state and federal. So you really got to understand how these interact with each other. Do realize that the 2018 Farm Bill removed all cannabinoids from the CSA. So if a cannabinoid comes from hemp, it is no longer a controlled substance on the CSA. Instead, it's under this framework, and really the DEA should not have any authority over that. Also, make sure that you understand that you should not be using templates from other industries. You could use templates, and I will provide templates through these classes that are very specific to your particular law of the state that you're operating in. So if you're doing a particular contract, if you're selling hemp, if you're a cultivator and you're selling hemp to a processor further down the supply chain, you're going to want certain provisions that are specific to this particular industry. So be very careful about these things. These are the do's and the don'ts. Thank you so much for attending this class. We're very excited to get into class 3, where we're going to go over what you need to know in order to win a marijuana license. Have a great day.